Hello, I'm Jeff Hampton with the Fulgham Law Firm. Today I want to talk to you about being charged with domestic violence charges in Texas. Maybe you've been charged, maybe you or a loved one has been charged. What steps should you take? Is there a way to potentially defend and dismiss the case? And by the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You've Been Charged with a Domestic Violence Crime in Texas. And I want to encourage you, if you like what you hear today, like this video, subscribe to our YouTube channel, and we'll send you more great criminal defense content just like this, all right? Now, let's jump right into this. Maybe you're facing a domestic violence charge, and I will tell you of all the charges to face, even if it's a misdemeanor or a lower level felony, it can be one of the most scary, intimidating situations because with it comes all these additional requirements. You are not able to then see your loved one that was involved in the altercation. There can be a no contact order, there can be an emergency protective order that goes into effect. Things can get very complicated. Then there can be the feeling of, how do I fight back? How do I protect my criminal record? How do I make sure to get my life back and move forward? So what we're going to talk about here is we're going to look at some of the defenses that can be used to protect you from the state of Texas and provide you the best opportunity to obtain a favorable result. Now, there's been recently in the last few years quite a bit of reforms that have taken place as it relates to Texas domestic violence laws. But as a result of that, one of the things we still see, and even though they've tightened it and they've made it even more in some ways punitive under Texas law, the judges still maintain wide discretion in sentencing and in other areas as to how a case may resolve if someone does a plea. So part of our goal is to try to do everything that we can to avoid our clients having to take that plea because of the consequences that can be involved after the plea. So one of the things we want to look at is let's identify the types of domestic violence cases that exist in Texas. And I'm going to go very quickly through these. Number one is assault by contact family member. Now, under this allegation, the state of Texas must prove beyond a reasonable doubt that you intentionally or knowingly contacted the alleged victim in a manner that was offensive. Literally. Doesn't even require pain or anything like that. No injury, just offensive, okay? Now, this is a Class C misdemeanor punishable by fine only. So there is no jail sentence for an assault by contact. You can receive up to a $500 fine. However, the state of Texas requires each and every person who does a plea deal or works out an arrangement on their assault by contact case to be fingerprinted and entered into the state's database for domestic violence offenders. So as a result of that, it is critical that you do not just walk in and take a plea deal to an assault by contact family violence situation, because if you do so, you may forever eliminate your possibility of being able to get your records expunged and cleared from your criminal record, okay? Now, number two, we're going to talk about assault bodily injury family member. Under this allegation, the state of Texas must prove beyond a reasonable doubt that you intentionally or knowingly contacted the alleged victim in a manner that caused pain, okay? So the injury is defined as pain. So technically, proof of injury is not actually required in order to prove this charge. But I am just going to be upfront with you. The failure of the state of Texas to be able to provide proof of that injury makes the case much more difficult for the state of Texas to prove, and it may provide leverage for your criminal defense attorney to be able to help get you a favorable result for your case, okay? Now, if you're charged with an assault bodily injury family member, if it's your first offense, it is a Class A misdemeanor punishable by up to 1 year in the county jail and up to a $4,000 fine, all right? Now, what if it's not your first offense, but what if it's your second offense? What if you have more than one instance of this? That can then, assault bodily injury family member with priors can actually be charged as a third-degree felony, punishable by up to 10 years in prison and up to a $10,000 fine. Now, the next charge I want to talk about is called assault impeding breath of a family member. Now, the state of Texas under this charge must prove beyond a reasonable doubt that you intentionally or knowingly contacted the alleged victim in a manner that impeded the circulation of their breath. Many people refer to this crime as assault choking, right? Assault by choking. It is important to remember, though, that the state of Texas cannot prove, if they're not able to specifically show that the victim was unable to breathe as a result of this contact, then the charge cannot be supported in court. It can't just be somebody walking up and putting their hand on someone's chest like this and making them scared and they start hyperventilating. That's not going to cut it, all right? It literally must be the impeding of someone's breath where they are unable to breathe. Now, if someone is convicted of this charge, it is a third degree felony punishable by up to 10 years in prison and up to a $10,000 fine. Now we're going to examine continuous family violence. Under this particular felony offense, the state of Texas must prove beyond a reasonable doubt that you intentionally or knowingly assaulted the alleged victim 2 or more times in a 12-month period. Now, here's where the key comes into this. If the state of Texas is unable to prove one of the assault allegations, so if they've got to prove 2 or more, but they have a hard time proving one of them, and this happens fairly frequently, because what ends up happening is the alleged victim didn't report one of the instances in the past, and then now the newest instance, for whatever reason, they decide to report and make an allegation. Well, if the state of Texas is unable to prove both of these allegations beyond a reasonable doubt, the charge would have to be a lesser charge of a Class A Misdemeanor assault bodily injury family member, okay? It would have to drop down from a felony down to a misdemeanor. Now, finally, let's talk about aggravated assault of a family member. Under this allegation, the state of Texas must prove beyond a reasonable doubt that you intentionally or knowingly contacted the alleged victim in a manner that caused serious bodily injury or the threat of serious bodily injury or death, or if a deadly weapon was used in the commission of the crime. Now, an aggravated assault of a family member is a second-degree felony punishable by up to 20 years in prison and up to a $10,000 fine. Now, let's talk about this for a second. I hear this phrase all the time, but Jeff, I didn't commit the domestic violence. And I hear this come from many of my clients, and although we completely believe when our clients tell us this, it's important to remember the scenarios of when people say, hey, my defense is I didn't do it. Well, how does that play out in court? How are you going to be able to actually convey that and protect yourself against someone in court? Well, number one is the defense of mistake. Okay, the defense of mistake. Generally, a victim of domestic violence is fully aware of who has committed the crime. There have been some situations, though, when there are multiple people that are involved in some kind of big altercation. We've represented people where literally 5 or 10 people of the same family were fighting each other, brothers, sisters, cousins, and one of them was at a family reunion, if you can imagine that. And they begin to become confused as to who was swinging at who, right? Well, if there was a mistake as to who was actually involved, or maybe there was dark outside and they're not able to tell, that's one example of where a mistaken identity can play in. But perhaps the most common example of the defense of mistake is the situation where the family member of alleged victim was extremely upset, not thinking clearly, and maybe at the time gave information to the police that may not fairly represent what actually took place. And listen, it's human nature for us to perceive things sometimes even in an exaggerated manner when we are upset and controlled by our emotions. In the heat of the moment, when things are very passionate and everybody's upset at each other, we have all said things in our life that we look back on later and we say, you know what? Number one, I think someone either misunderstood what I meant by this, or I overreacted under the heat of the moment in how I perceived what took place. I mean, how many times have we been controlled by our emotions and we've said something that later on we regretted that we said? And we wanted to take it back. Well, we find that this happens all the time, okay? So sometimes if an alleged victim gave maybe some unclear information or some information that maybe just didn't accurately reflect what happened, the state of Texas needs to know this, because the state of Texas has the burden to prove the allegations beyond a reasonable doubt. Now, what can be done if your case is based upon mistaken evidence. Now, if the alleged victim that's a family member is willing to come forward and reveal what they're thinking, and they want to make sure and let the state of Texas know how they feel about this, it's very important that they could do what's called an affidavit of non-prosecution. Now, what is that? An affidavit of non-prosecution is a form that allows the alleged victim in a case to provide evidence to the state of Texas. It literally becomes a valid piece of evidence, just as valid as a police report or a video or anything else, that allows the prosecutor to understand what actually took place, as opposed to maybe what our emotions said took place at the scene, okay? So it's really important that you should contact your criminal defense attorney, and if you are interested in us helping you with this process, time is of the essence. It's very important that that alleged victim convey that information in an affidavit as soon as possible. Because here's why. Let's say that domestic violence is a felony case. Well, because it's a felony, that affidavit could be presented to a grand jury in an evidence packet. Now, here's the thing. The grand jury is a panel of citizens for every felony case that must listen to evidence and decide whether or not it's legitimate. The grand jury could review this new evidence that's presented through this affidavit, weigh it against the other evidence, and they could possibly lower that charge to a lesser charge down to a misdemeanor. Or if they believe that evidence does not substantiate those charges, it could be no-billed by the grand jury. Now, a no-bill is literally the equivalent of your domestic violence charge being thrown out for lack of evidence, okay? Now, finally, here's one of the other ones is people say, well, what if my ex or my family member is flat out lying? Well, sometimes there are false allegations that can take place. This happens very frequently in heated custody battles and divorce situations. So often your defense team needs to go through the accuser's story and compare them to police reports and other eyewitness testimony that's there and look for any type of inconsistencies. And it's really critical to identify. Look at the alleged victim's statement. Look at the time, the place, and the facts of those allegations. We've had clients that then, after we look at that information, we can identify texts, emails, even communications between the alleged victim and other witnesses. We could gather statements and affidavits from those other witnesses who kind of put a different spin on this, saying, no, it doesn't really make a whole lot of sense. That's not consistent with what I saw when I was with that person at the time. All of that could be enormous in challenging the credibility of the alleged victim, okay? Finally, one of the other ones I wanted to talk about, one of the final defenses we can discuss is, I have an alibi. What if you have an alibi? What if you weren't where they said you were, right? And you could maybe provide hard evidence of an alibi. We've had clients that have provided us literally digital proof of their location. Had a guy with a concert ticket showing right where he was. He couldn't have been where this other place was. Another person who had photos of him time-stamped with other people at the same time that the alleged victim claims that there was an assault taking place. But even if you don't have that type of digital proof, you might have other witnesses that you were with at the time that would be willing to provide an affidavit that you could then use as proof. Even if it's circumstantial evidence, it's still evidence to establish that you were with someone else at the time the alleged incident took place. Okay, finally, what if I've had some clients say, listen, I did do this, but I don't know what got into me. You don't understand what my past is. I had a terrible childhood. I was abused when I was younger. This is something that I just accidentally exploded. Well, let me just tell you this. If it's your first offense, and even if it is true that it took place, there are still options available where you may be able to get your case dismissed. And what I mean by that, there are diversion programs that are available where you can receive maybe some counseling, receive some assistance, but at the end of that counseling and assistance, there is the potential payoff of the case being dismissed, and you could still potentially get that removed from your criminal record. So the last defense I want to talk about is the defense of self-defense, okay? Self-defense is known as an affirmative defense under Texas law. So what it requires you to do, it requires you to admit, yes, I did do this assault, but I did it because it was justified under the law. In other words, you only assaulted your family member or roommate or whoever you were involved in response to being placed in fear of imminent serious bodily injury or death. We've had this happen many times where we've seen, we had a lady that we represented where she was being charged with assaulting her boyfriend, but her boyfriend had assaulted her in the past and was now threatening and coming at her to assault her. So she, in an attempt to protect herself, jumped out and tried to do something to prevent him from hurting her like he had done in the past. Well, that's important. In order to use this defense of self-defense, you must be able to establish three things. Number one, you've got to show that you did not make the first move, that the other person was coming at you and they were being threatening towards you. Number two, that you reasonably perceived an imminent threat against yourself or another family member, okay? And then number three, you acted purely in response and you responded proportionately to the aggression headed at your way, okay? And if that's the case, you may have a very strong defense for self-defense. Finally, I want you to understand, there may not be any evidence in your case, and maybe only it's the word of the accuser. Don't forget, the state of Texas has the burden to prove this case. And not all evidence that's being claimed as evidence is admissible in court. So that's why it's so very important that you get an attorney that's able to fight this case. Because I want you to understand, if you take a domestic violence conviction, you're no longer able to own, transport, or possess firearms. You can limit your other rights that you have under the Constitution if you take a conviction where it can be permanently on your criminal record. All right, I've gone long enough on this. If maybe you or a loved one are facing a domestic violence situation in the North Texas area, we would be happy to give you a free case analysis and a consultation. Don't hesitate to contact the Fulgham Law Firm at 817-877-3030. And by the way, I promised you if you waited around to the end of this video, I would give you a free ebook, What to Do If You've Been Charged with a Domestic Violence Crime in Texas. Click the link below and I'll be happy to send it right over to you. All right, thanks again for joining us on our YouTube channel. Look forward to seeing you on our next video series.